Anytime you're bringing a claim against someone who is a professional, that could be an engineer, could be a lawyer, in this case we're talking about doctors, it would be required that you have talked to an expert, you the attorney in that particular instance, before you even file the lawsuit in New York State. That's required. As a lawyer, I have to not only review the records, I have to talk to a doctor who's reviewed those records, and then we both have to agree. If I don't do that, I'm not supposed to file that lawsuit. So that's adhered to, I think, quite strictly. If I'm at the very tail end of a statute of limitations period, I can file it, but then with a very short order, I have to talk to that expert. Going forward, in order to present the case at trial, that expert or experts, in many cases, there can be 2, 3, or more experts required, depending on the facts of the case. They are obliged to give testimony before the jury to tell the jury what happened in the particular case and what their opinion is as to whether or not what occurred was medical negligence or not, and then that medical negligence was a cause of injury to this patient. And then they have to tell them why they've come to that conclusion, and to then persuade that jury that what they're telling them is in fact accurate and should be relied upon by the jury at the end of the day. Otherwise, we would have simply a case in which people are offering their opinions. The patient obviously feels injured. The doctor says, I don't think I did anything wrong. There would be no way for the jury to come to a reasoned decision if they didn't have experts to testify so that they could get that full sense of what has happened and what the position that they're ultimately going to take should be.